Reservation should not be allowed to become a vested interest. Real solution, however, lies in eliminating the causes that have led to the social, educational, and economic backwardness of the weaker sections of the community. This exercise of eliminating the causes started immediately after the independence, that is almost 7 decades back, and it still continues. The long-standing development and the spread of education have resulted in tapering the gap between the classes to a considerable extent. As larger percentages of backward class members attain acceptable standards of education and employment, they should be removed from the backward categories so that the attention can be paid towards those classes which genuinely need help. In such circumstances, it is very much necessary to take into review the method of identification and the ways of determination of backward classes, and also ascertain whether the criteria adopted or applied for the classification of backward is relevant for today's conditions. The idea of Baba Saheb Ambedkar was to bring social harmony by introducing reservation for only 10 years. However, it has continued past 7 decades. Reservation should not continue for an indefinite period of time so as to become a vested interest. In the result, I hold that the impugned amendment is valid and in no manner alters the basic structure of the Constitution. Thank you.
Finally, I invite Justice Savindra Bhatt to place it.
Big update coming in from the Supreme Court of India. 3 judges have batted for the EWS quota for the 103rd Amendment of the Indian Constitution. With 3 out of the 5 judges in favor of the 103rd Amendment of the Indian Constitution, now it is a thumbs up. EWS quota is good in law. It's not violative of the basic structure of the Indian Constitution and the scheme of the Indian government to give some kind of reservation for economic upliftment of certain communities which were earlier not recognized has been given a go-ahead by the Constitution bench of the Supreme Court. We say this on the basis that 3 judges on the bench, I'm going to read out the names, Justice Dinesh Maheshwari, Justice Bela M. Trivedi and Justice J.B. Pardiwala, have said that EWS quota does not violate the basic structure. This was the moot question. The moot question was that the basic structure is that you give reservation based on social and historical factors, not on the basis of economic factors. The argument of the government was we have the right through our legislative wisdom to create a new category. That is exactly what we have done. And this EWS quota was then challenged in the Supreme Court with about dozens of petitions lined up. The court heard the arguments at length and today has delivered this big judgment. EWS quota is good in law. It is not violative of the basic structure of the Indian Constitution. It does not fall foul of the Indira Sani judgment that prescribes a 50% ceiling. The argument of the government is that the 50% ceiling is only and only for SC, ST and OBC communities which have been recognized in Article 15 and 16. With this amendment to the Indian Constitution, the government is creating a new class. And under this new class, the government has the right to do so because there are various factors which have led to the disadvantage of some communities, quote unquote, the forward classes. It was also said that under this reservation, you are excluding the SC, ST, OBC. So you are violating the Equality Code. The Supreme Court of India says that no, you are not violating the Equality Code. So this is a big win coming in for the government of the day that had brought in this amendment. The amendment by the Parliament can only be tested by the Supreme Court on the principles of whether it's violative of the basic structure of the Indian Constitution or not. 3 judges on the bench believe that this quota brought in by the government, legally speaking, the 103rd Amendment to the Indian Constitution is not bad in law. EWS quota, the government can go ahead, notify it, various state governments can go ahead, notify it and create a class. This opens a new chapter in India's reservation policy. And I want to assert that because so far in the history of independent India, largely speaking, yes, there are some kind of reservations that exist at the local level in the right to education and various other factors. But to create a separate class altogether, not via notification, but via an amendment to the Indian Constitution under Article 15 and 16 was a sweeping big step that the government had brought in. That big step was challenged at the Supreme Court of India, and that challenge the court heard at length and has come to the conclusion not violative of the basic structure, not violative of the Indira Sahni judgment. The government can go ahead and implement this law. There were some very interesting observations that came from Justice Pardiwala when he was reading out his judgment. He said reservation should not be a political tool. He also said that when Baba Sahib Ambedkar envisioned and spoke about reservation in this country, it was not supposed to be forever. So we must strive for a society where at one point we can do away with this kind of reservation. While saying that, he said, I agree with the 103rd Amendment. Ananya Bhatnagar, my colleague, getting us all the details on this very important story. There's a dissent that I want to tell our viewers about, which is by Justice Ravindra Bhatt. Justice Ravindra Bhatt disagrees. Dissent means that he's not agreeing with the other judges on the bench. Our constitution doesn't permit exclusion. The amendment undermines the social fabric. That's what Justice Ravindra Bhatt is saying. He's in the process of reading his judgment. Well, what we haven't heard so far is from the Chief Justice of India, Justice UU Lalit. So it's a big victory coming in for the government of the day. This 103rd Amendment to the Indian Constitution was challenged in the Supreme Court. A 5-judge constitution bench was formed. What was the moot question? Why was it that when the government brought in a 10% reservation for the economically weaker sections, there was a challenge in the Supreme Court? There were multiple organizations and individuals that went to the court and said, look, reservation in this country has been done on the basis of historical social injustice and discrimination. Reservation is not a tool for financial upliftment. If you want to do financial upliftment, use your welfare schemes, use your targeted welfare schemes, but reservation is not the answer to this. The government of the day said that SC, ST, OBCs, the 50% ceiling limit applies to them in the Indira Sahni judgment. If we want to create a separate class under Article 15 and 16 of the Indian Constitution, we have the right to do so. The government also said that there is a basis, if you look at past many decades and what has happened, to really argue that there are various quote-unquote forward classes which have not found the right kind of opportunities, and that must also be recognized. For the benefit of our viewers, I reiterate, it's a big victory for the government. 3 judges are in favor of the EWS quota for the economically weaker section. This does herald a new chapter in Indian constitutional history. The first step that the government had already taken, that on the basis of your economic background, you can get reservation. That was challenged in the Supreme Court, and with none other than the Constitution Bench of India giving its stamp of approval and saying that yes, you can go ahead, you can grant reservation basis on the economic status. It is a big step forward. We are going to see the ripple effects of this entire judgment across various states in the country, whether it's the Jat reservation, the Maratha reservation, and various other reservations. All right, so this is a big judgment coming in from the Supreme Court. Taking the proceeding and the broadcast forward is my colleague Reha.
Thank you so much, Anusha. And of course, this is a historic development that is coming in from the apex court of the country, as the country has gone ahead and upheld the fact that EWS quota does not violate the basic structure, as the Supreme Court of the country has upheld the 103rd Constitutional Amendment. Remember, this amendment had introduced a 10% reservation for economically weaker sections of the society in admission to educational institutes and government jobs. So this is what has come out of the Supreme Court, as the Supreme Court, while hearing a clutch of petitions challenging the constitutional validity of the 103rd Amendment to the Constitution, had said that the reservation on economic basis does not violate the essential features of the Constitution. Let me take this across to Mr. Ashpreet Singh Kadial of the Congress, who's joining us on the broadcast. Mr. Singh, something historic that's come out of the Supreme Court. However, this is also backing the government's endorsement. What do you have to say? Mr. Singh, could you kindly unmute yourself? We are not able to hear you. Mr. Singh? We'll try and reconnect with our guests on the broadcast, and we'll get that audio line fixed with Mr. Ashpreet Singh Kadyal of the Congress. However, this has come out of the Supreme Court today as the amendment which had introduced a 10% reservation for economically weaker sections of the society in admissions to educational institutions and government jobs has now finally been upheld by the Supreme Court of the country. Remember, this was a 5-judge bench of the Supreme Court. This was led by the Chief Justice of the country, U. Lalit, and he was the one who pronounced the judgment. And reading out the order, in fact, Justice Dinesh Maheshwari went on and said that EWS reservation does not violate the Equality Code or violate the essential feature of the Constitution, and also talking about the breach of the 50% is also not valid here, as it does not violate the basic structure, as the ceiling limit is here only for Article 16. That is what has been put forth as far as this particular judgment is concerned. He also went on to say that reservation on economic basis does not violate the basic structure of the Constitution of the country. This is what was challenged in the Supreme Court. Judgment there coming out of the court. The Supreme Court has further stated that the reservation instrument of affirmative action by state is to ensure that all march to the goal of egalitarian society. This is what the court has said today. And I quoted here, it has also gone ahead to say that for the inclusion of any class or section disadvantaged, economically weaker sections quota should be made applicable. It does not and doesn't violate the features of Constitution or damage its basic structure. Pretty much out there, why is the EWS reservation, why was it even taken up to the apex court of the country? If we look at the case so far, this was also calling the amendment an attack on the constitutional vision of social justice, like I mentioned, and a fraud on the Constitution. This was the challenge before the apex court of the country. And in fact, those petitioning against it also contended that if upheld, it will end the equality of opportunity. For better understanding of what's come out of the Supreme Court, let me take this across to my colleague Anusha, who's been tracking all the developments to break down the order that's come out of the apex court of the country. Anusha, please take our viewers through what exactly happened. I believe there was one dissenting argument that came from one of the judges.
Yes, Justice Ravindra Bhatt, Ananya Bhatnagar reporting all the details from the Supreme Court as the 5th judge has already given its verdict. How is it, viewers, that we have reached this conclusion? 3 judges on the bench, which includes Justice Dinesh Maheshwari, Justice Bela M. Trivedi and J.B. Pardiwala, have already given their stamp of approval as far as the 103rd Amendment to the Indian Constitution is concerned. What does that mean? It means that EWS quota is good in law. It is not violative of the basic structure. You can give reservations in this country based on the economic status. The argument that was put out before the Supreme Court is that it is only on the basis of historical social exclusion that the scheme that was put out by Baba Bhimrao Ambedkar, that you should have reservations in this country, was brought forward. If you are economically disadvantaged, you cannot get reservations. You should have financial welfare schemes coming in from the government. The argument of the government was, we have the right to create a special class beyond the 50% prescribed in the judgment of Indira Sani. We are creating that category, and we now want to give benefits to those people who are economically disadvantaged in this country. The Supreme Court of India, the 3 judges have agreed. You know, Griya, what is something we wait and watch is that the Chief Justice of India, Justice U. Lalit, is yet to read out his agreements. He is yet to read out his own judgment. Justice Ravindra Bhatt disagrees. He says that there is an exclusion in that amendment, and it's this short page, 1-page, 2-page amendment that government has brought in. Here it says that the communities like SC, ST and OBCs will not be covered under the economically backward classes for the simple reason that they are already covered under various other provisions of the Constitution. Yes. The argument of the petitioners was that this in some way violates the Equality Code under Article 14. 3 judges on the bench at least think it does not violate the Equality Code. What we also wait and watch out for is the judgment of the Chief Justice of India, Justice Lalit, who's all set to retire tomorrow.
Absolutely. Anusha, let me take this across to Ashpreet Singh Kadyal of the Congress, who's now joining us on the broadcast. Mr. Singh, The fact that the Congress did not go ahead and oppose this law, however, this thing coming out of the apex court of the country, upholding of EWS as a 10% viable quota, what do you make of this coming out of the apex court?
See, number one, before the BJP had even touched upon this issue, the Congress party used to vouch for it, used to ask for it, demand for it, and it was also included in our manifesto of 2014 that if the Congress party comes into power, we will make sure that there is a quota for the EWS section of the society. And number two, with regards to, the EWS quota demand then was, and that it should not touch upon SC/ST quota. It should be a quota of itself, shouldn't infringe upon the quota of other, communities as well. So that every community, every section that requires reservation, therefore all of them could be passed on the benefits of it. So therefore, it's a good step. We are looking forward to it and hope that the Bharatiya Janata Party would be able to implement it soon.
Right. Mr. Singh, thank you so much. Let me actually take this across to my colleague Arunima, who's also joining us on the broadcast. Arunima, something important coming out of the apex court of the country. Like Anusha was mentioning, Justice Lalit is yet to actually pronounce his observation. However, this also sort of is a big thumbs up to the key vote base of the ruling BJP, because this is also the key poll plank of the BJP. Now that it is underlined that this is not violative of the fundamental structure of the constitution, that's something that is going to be a big push for the ruling government at the center.
Yes, we've discussed the legalities, but just to give you a sense of the politics of this all, this amendment was actually brought in by the current government after the laws in the assembly elections of Madhya Pradesh, Chhattisgarh and Rajasthan. Back in 2019, these three assembly elections were lost by the Bharatiya Janata Party, and soon after, this amendment was brought in because there was this sense that the upper caste, which was poor, which was deprived economically and was not getting any benefit as far as reservation was concerned, they were unhappy and they are a part of a core vote bank of the Bharatiya Janata Party. So political analysts felt that the reason this amendment was brought in was to assuage the feelings of that section of the upper caste, which felt that they were as poor as, perhaps an SC or an SC or an OBC, but because of their caste, because of the family that they were born in, they were not enjoying any reservation. This is exactly what Justice Ravindra Bhatt in his dissent is also quoting. He's saying that, it is wrong to suggest that those who have got reservation benefits, their economic status has improved in any way, and therefore excluding them from any kind of quota. This 10% quota, the petitioners had said, is excluding the SC, ST, OBC. And the ground was that if you're excluding anybody, that is unconstitutional. Of course, that's just a minority view. 3 other judges have said that there is nothing wrong as far as the 103rd Amendment is concerned. It does not alter the basic structure. It does not play with the 50% quota ceiling that was given in the Indra Sahni judgment. The last judge's view is only for academic interest, but now it's more or less certain that the Supreme Court has found nothing wrong with the government's decision to bring in 10% quota, 10% reservation for those who are economically backward, irrespective of their caste status.
Right, Arunima, thank you so much. Let me take this across to Swapnil Kothari, who's an advocate, who's joining us on the broadcast. Mr. Kothari, first of all, what do you make of all that is coming out of the apex court of the country?
Well, Griha, let me tell you, this is a judgment as expected. I was on another channel before the judgment came through, and I said that the constitutional validity will be upheld simply because no way does the 103rd Amendment, the way it has been drafted, violates first the basic structure of the Constitution, and two, in any way go against the judgment of the Mandal Commission. Because if it were going to go, because it was a 9-judge bench decision, then it would have been 11 judges here instead of the 5. So there is no question the two issues at hand are dissimilar. They are not similar. So the question of any overlap doesn't arise, or any infraction of that particular judgment does not arise. Now, to make it very simple for your viewers, as to what is the meaning of basic structure of the Constitution, because that lies at the root of all of this controversy, that the petitioner said that it violates and the government said that it doesn't. The basic structure means the fundamental rights, the principles of state policy, judicial review, parliamentary form of government, bicameral legislature, amendment procedure. So all of these 6-7 things that constitute the basic structure of the Constitution are sacrosanct. They cannot be played around with or toyed around with. So whenever a new amendment comes in, an amendment is basically what the will of the people passed by both the houses of the parliament, or a presidential ordinance which is only done by the president. So here there is a question of both the houses of the parliament passing a 103rd amendment. So it's the will of the people. Obviously, it has to withstand the judicial scrutiny because judicial review, once again, is a part of the basic structure of the constitution. So here it was for the judicial review of the same, before the apex court. And the court reviewed it, and the court came to a conclusion by 3:2 at the moment, or 4:1. I assume that Mr. Lalit will also concur with the majority opinion. So it's 4:1. I would not go into that, but anyway, I would say the majority view is that this is valid. So it does not violate the basic structure, because here what the basic aspect was, the challenge by the petitioners was that it violates Article 14, which is the equality code, the equality clause of the Constitution, which in turn is a fundamental right, which in turn is a part of the basic structure of the Constitution. So it does not violate Article 14 simply because here I'm looking not at the Dalivasis and the caste system and the Dalits or the Adivasis or anything of that sort, the lower rungs of the society. I'm looking at economically weaker. They could be even from the Brahmins.
Okay.
So what I'm trying to say is that these people who are belonging to the upper class but do not have the money to go to a private unaided institution for that matter. I'm just giving you a simple example. Or anywhere, say, occupying a position at CNN News18 or anything of that sort. I'm just stretching the argument.
So one thing, when we talk about the arguments and the observations that have been made by the various judges today, one important thing that also came out is by Justice Pardiwala, where he goes on to state that reservation is in the end, it should not be allowed to become something sort of a vested interest. He also says that it should not continue for indefinite time. What do you make of these observations?
Well, definitely what he's trying to say is, and I think that was echoed by Bela Trivedi also, Justice Bela Trivedi also, that there has to be some time span. You cannot continue with this reservation, quota business so as to really then deprive the meritorious ones. But you see, the Article 46 is a directive principle of the state policy. It's not binding on the government. That talked about, bringing up the weaker sections of the society. All the several judgments that have been there in the past 70 years, some of them primarily the Mandal Commission, which was in issue here. In an indirect form, is also talking about reservations, gave that 50% reservation. Obviously, 15.4, 16.4 and all of those things, articles also talk about reservations. So what we're basically talking about is affirmative action. So there has to be some sort of a time limit, Griya. But, with due respect to His Lordship, Mr. Pardiwala and Ms. Bela Trivedi, is that even the affirmative action prevails even in the United States today after 276 years of independence. So, or say 260, I don't know exactly, 1776, what is the maths now, possibly 252. So the thing is that, 246 to be precise. So it prevails there even in the United States, so why not in this country? This is a country of 1 billion people, that's a country of 300 million people. Yeah. So obviously it's going to take at least another 20 to 30 years, Griya, before we really see that reservations do not form part and they're done away with. We've still got to deal with linguistic reservations. We've still got to deal with certain other reservations which do not form part of the linguistic minority or the weaker minorities. There could be still some, in the womb of time that could come up or crop up before the apex court. So the judges are sounding out a cautionary note, trying to say that we cannot go on with this for a longer period than what is necessary. So please bear this in mind. And they're giving this for the future judges to hold this. That please bear this in mind so that do not do away with merit.
In fact, Swapnil, I'm really sorry. We are putting out this breaking news for our viewers that even while observations are coming out of the apex court, the Chief Justice of India has dissented. This is a big development that has come out. So this is the 3:2 ratio judgment that has come out of the Supreme Court of the country, with the Chief Justice of the country, Lalit, also going ahead and dissenting with the arguments placed. Let me take this across to my colleague Anusha to break it down for us. Yes, Anusha.
Well, Griya, the judgment is there. 3 judges on the bench have already given their stamp of approval to the EWS quota. So as far as the 103rd Amendment to the Indian Constitution is concerned, that's good in law. That position doesn't change. But I say this as a student of law, that dissents have a very important place in jurisprudence. The fact that it's none other than the Chief Justice of India who presided over the bench has dissented along with Justice Ravindra Bhatt, it's going to arouse some academic and judicial interest in terms of the reasons that they have cited. That being said, EWS quota, good in law, not violative of the basic structure, a victory for the government which had brought in this policy, but are all eyes on what precisely the reasons are, why Chief Justice of India, thinks that the 103rd Amendment to the Indian Constitution is actually violative of the basic structure, because that is the sole basis on which the Supreme Court or any judge on the bench, of the Constitution bench can actually say that 103rd Amendment is bad in law.
Yes.
So the argument coming in from the Chief Justice of India is going to be very interesting, who's set to retire tomorrow.
Absolutely. Anusha, let me take this across to my colleague Ananya, who's also with us on the broadcast, who's brought us this breaking news input. Ananya, very important development once again coming in. The argument that possibly has come to light, one of the other dissenting judges, Justice Bhatt, also talked about the breaching of the 50% cap. Do you think, UU Lalit is also going ahead with the same argument? And also the fact that giving more quota to SC/STs above and beyond what they already have. Was that also part of the discussion?
All of this was a part of discussion, but at the heart of it, at the biggest part of it, it's a 3:2 judgment. It's a judgment wherein 3 judges have concurred and said that there should be the 103rd Amendment to the Constitution of India is completely valid in law, while 2 judges, Chief Justice of India, Justice Uday Umesh Lalit and Justice S. Ravindra Bhatt, has actually dissented with this particular opinion and said that the 103rd Amendment of the Constitution of India is actually invalid and unconstitutional because it excludes the SC/STs and OBCs, and that's the big piece of breaking news that is coming out of the Supreme Court. This was a 5 judges Constitution bench which has just now pronounced its verdict, but
definitely, though it's a 3:2 judgment, though there are 2 dissenting judges on here on, and as Anusha was pointing out, dissent has a very, very important point to play when it comes to academia, when it comes to debate. But at the same point of time, it's a big, big win for the central government. It's a big, big win for the 103rd Amendment that's been brought in. And it's not only that, but also a big, big win for the EWS category of the upper caste who would continue to get this reservation of 10%. In fact, the 3 judges who have concurred into this opinion, a very important point came up from Justice Bela Trivedi that the reservation system, after 7 decades of independence, after 75 years of independence, has to be relooked into. And that's the very, very important point that is coming from Justice Bela Trivedi, who has concurred with the opinion of other 2 judges. In fact, there is a need that is there for the reservation to actually be relooked, and the 103rd Amendment of the Constitution of India has been upheld by the Supreme Court in a 3:2 ratio, where 2 judges, the Chief Justice of India, Uday Umesh Lalit, and Justice S. Ravindra Bhatt dissenting, while the other 3 judges concurring to this opinion. Studios.
Right, Ananya, thank you so much. Let me take this across back to my guests who continue to be with us on the broadcast. Swapnil, I'll come back to you. You were making that point, but let me add to it now that we have come out of the Supreme Court and this is what is happening. 3:2 judgment with 2 dissenting judges, one of them the Chief Justice of India, Justice UU Lalit. He, in fact, while this entire verdict was being looked at, had also observed that economic basis cannot be a permanent criteria. And probably on the basis of that also, the dissent has been underlined.
Yes, in fact, Anusha is absolutely right there that the dissenting judges do matter a lot, rather their judgments do matter a lot. They sometimes pave way for a majority judgment in the future where, things could be different, circumstances could be different. 20 years down the road, maybe the dissent would be viewed more as a majoritarian view and quoted, and this whole thing would be upturned on its head. So, the economic sections do not, for a longest time, I think they do matter in some form. There, with due respect, I disagree with his lordship, and I would be interested to know his dissent in more in detail as to, apart from the precedents that he may quote. But I disagree with him there because today the current climate is such that there are people who are extremely poor, there are people who are below the poverty line. There are people, even in the forward classes, even the Brahmins or Kshatriyas, who do not have that kind of money to go to a good college or a good university, for that matter. So they will require that particular reservation to boost them up, to bring them along with, to see the, simply put metaphorically, the light of the day, or see the dawn the way you and I do. So the thing is that, to pave way now by dissenting, say that 20 years down the road, maybe my dissent could be, taken as a majoritarian view, and that is possibly there in the minds of the Chief Justice and also Justice Ravindra Bhatt. And this is usually happens in the Supreme Court. They tend to look about 30, 40 years down the road and say that, look, if there are 3 majoritarian views, which they obviously would have been aware of, let me take a dissenting view, even if I may intrinsically agree with her majoritarian view. But let me pave this way now to say that, look, this is also to be there and looked at by the government in question tomorrow, or say by even the policy framers, or even by the policy makers, or even by private unaided institutions, because that is where the crux lies. Because as a private unaided institution, if I'm super rich, I do not want any government to tell me what I am supposed to do in my institution. I'll say, to hell with all the reservations, I don't care. Nobody is there to prescribe some 10% to me. I don't give a damn about it. I'm already have given meritorious scholarships based on the basis of merit to even poor people. So I'm doing my job. So the thing is that this is where the dissent has its value. But to totally dispense with the economic aspect is something which I do not think that Baba Sahib Ambedkar would have agreed with, or today even most of the senior advocates would agree with this view today. And maybe one-on-one justice, Lalit could enlighten us. As we often have post-retirements, we often have these one-on-one talks with them, and they go in this litany of judgments, and the way they look at the constitution and the way they see that into the future, and it's a great exercise. It's great to see, because you have the most brilliant minds occupying the bench today in the Supreme Court, in the apex court. So basically, you're looking at people who are visionaries. So it's great opportunity for us also, even after 28 years of practice, where even we can tell them a few things, with due respect, I disagree or I differ. But this is something which I would really be happy to read, both Mr. Bhatt, because their dissent comes out very strongly, especially Justice Bhatt, because I could hear him. He is coming out very strongly against it. So I would want to know, even if I vehemently disagree with him, but I would want to know what his reasoning is behind totally dispensing with the 103rd Amendment.
So Swapnil, while you mentioned that dissenting judge, Justice Bhatt, he also mentions that the breaching of the 50% criteria would lead to the formation of compartment classes. And that's his basic idea. And also challenging the exclusion of SC, ST and OBCs from this EWS criteria is something that he said is not constitutionally viable, an option.
Well, that's, he's what he's trying to do is he's trying to compare the economic sections with the OBC quota and all of those things. That this is where my fundamental difference lies. Let the Mandal Commission judgment, Indira Sawhney, lie alone. Do not bring that into play. That was a separate judgment. It was by 9 judges. You say that, somewhere there seems to be an overlap. There seems to be more reservations. Maybe that is your reservation against the reservations where you're thinking that merit is going to take a backseat. The short answer to that is no. The simple way of looking at it is that if there are certain poor people, I want to make people who will say that, look, I don't even have an income tax return because my income for the whole year is below 4 lakhs or 5 lakhs of rupees. How do I go to a good college, or how do I go to a good university? And that is simpliciter. The state is trying to pave way for that, because there was no need to mention the unaided and the aided part both in that 103rd Amendment. Why do you take that particular? They are looking at education, basically. That is the fundamental, because the right to education is a fundamental right. And that is where the 103rd Amendment is trying to bring in more people, make people more educated, because that is the root and the base for progress. So if Justice Lalit were to look at it this way, then maybe he would have arrived at a different conclusion. But I think he has his views set on a certain way, and he's entitled to that. But with due respect to him, I do not see an overlap between the OBC quota and the economic weaker sections, because an economically weaker section is in a class by itself, as Justice Bela Trivedi pointed out.
Right, and that's a very important point also, Swapnil, that you'd made, quoting Mandal Commission as well. We have to also underline this for our viewers, that it was not here to stay. We actually were waiting for it to actually come to a level playing field, and that was the entire argument, which also made it to the court today. We will take that question to Ashpreet Singh, and also my colleague Ananya would like to take a couple of questions, but allow me to take a quick break, and I'll come back to you with the same story.
Governor as Chancellor has given to the Vice Chancellors to respond. He had sent a show cause notice to 11 of them, and they have time till today. So 6 of them have already responded, and we are expecting that the others is also most likely to submit their response by today. So it's after that the governor will take into consideration all this, and then he'll take a decision on this. So it was after the Supreme Court verdict on one of the Vice Chancellors, that is the Vice Chancellor of APJ Abdul Kalam Technological University. It was after that Supreme Court order which found that appointment not valid because it did not fulfill the UGC guidelines. So based on that, the governor is saying that all these 11 Vice Chancellors appointed appointments do not fulfill. So based on the Supreme Court order, he has to do that. As Chancellor, it was the governor himself who had appointed all these 11 people on the recommendations from the Search and Selection Committee.
Face-off between the governor, Arif Mohammed, who you can see on the left side of your screens, and the Kerala government continues. This is just one more chapter. You might remember that a little while ago, the governor had given a show cause notice to 9 university vice-chancellors. 6 out of the 9 have responded. These VCs have moved the Kerala High Court last Wednesday against the show cause notice issued to them by the governor. Remember, what the governor was alleging was that the appointment process of the vice-chancellors violated the University Grants Commission norms, and because of that, they must resign. Now, I want to take you through reactions to this story, then we'll connect with my reporter on the ground.
I have repeatedly said it and I'm repeating, please. Whatever you want to do, first do it, then I will say. I have said I consider media very important. I have always responded to media, but I am not now able to persuade myself to those who masquerade as media, but they actually are members of the cadre party. So if anybody is here, my request is please go away from here. I won't talk to anybody from Kerala. If any camera is there, I will walk away. I hope there is no Kerala here. I hope there is no media one here. Is there any media one? Yes, is there any media one? Yes, sir. I don't want to talk to you. Get out. I won't talk to you. And I won't talk to Kerala. Please go away. I will not talk to media one. You had sent the request, they might have. You are settling score.
Welcome back. You're watching CNN News 18. I'm Griha Atul Siddiqui. We're talking about the 3:2 verdict that's come out of the Supreme Court regarding EWS quota. And while the apex court of the country has upheld the EWS quota, Congress's Udit Raj has hit out at the very court and called the top court of the country as casteist. He has tweeted out, let me quote him here, Supreme Court is casteist, still no doubt. When it came to EWS reservation, it was preserved and the 50% limit also was not treated as a constitutional obligation. But whenever it came to giving reservation to SC, ST and OBCs or the economically backward classes of the society, the 50% limit in the Indra Sahani case was always cited. My colleague Shireen Elizabeth is joining us on the broadcast. Shireen, a voice, very strong one at that when it comes to the Congress. However, the Congress party did not go ahead and challenge this very, verdict that's come out, and they did not have any problems when it was actually brought about by the government at the center. So why this word by Udit Raj?
Well, Udit Raj is in fact someone who is known to be a voice for the SC/ST community. He is in fact the member of the SC/ST department also. He has never been shied away from talking on these issues. And we have seen that he has always taken lines which are in fact very different from what the party's line is. And today he has made a very big accusation on the EWS verdict by the Supreme Court, calling the Supreme Court as a casteist. He has in fact went on to say how the EWS reservation doesn't seem to be a big issue for the Supreme Court. They say that this can be in fact flexible, but when it comes to the SC/ST reservation, they always had issues. They always had problems that how it can cross the 50% of the reservation is something that has been an issue for them. So clearly, this accusation that is coming, the big claim that is coming from Udit Raj, he in fact, has always taken a different stand, because like you mentioned, whenever we talk about the EWS, the Congress has never really openly made any kind of statement. They have always agreed with the 10% EWS that was in fact released by the government in 2019. They have never taken any stand against it. But Udit Raj making this claim, of course, but he is also known to be someone who takes a different stand. So if this is his individual stand or is it the party's stand is something that has to be clarified. But a big claim calling Supreme Court
Absolutely.
a
So let me
caste
actually
list.
take this across to Mr. Ashpreet of the Congress. Mr. Ashpreet, the fact that there is another dissenting and a very strong argument at that coming in from Udit Raj, how does the party now choose to respond to something like this?
Well, since we are discussing dissent and since we are discussing, different things that are apart from the judgment, the Bharatiya Janata Party otherwise is in favor of the economically weaker section. But considering the flats that are being delayed by 6 years, that the Congress Party, a project that the Congress Party had brought in, the Bharatiya Janata Party delayed it, and 68% was not being able to deliver on their promise. This goes on to suggest that the Bharatiya Janata Party blows hot and cold at the same time. On one side, they say we are in favor of the EWS. On the other side, they do not want to build flats for the EWS. Number two, with regards to the EWS stand of the Congress Party, I think it's important to mention that it was Rajiv Gandhi ji, PV Narasimha Rao ji, Manmohan Singh ji that had paved the way for the EWS quota and had laid the groundwork. This has to be taken into account. This has to be taken into consideration, because the Bharatiya Janata Party, some leaders say yes, some leaders say no, but we have always been in favor of the EWS quota, and we hope that the Bharatiya Janata Party would also deliver upon their flats. As far as the judgment is considered and concerned, it's a historic step. We're looking forward to it, and we hope that it would bring, reprieve and relief to the economically weaker section of India.
Okay, sometimes what, neutrality also augurs to the line of confusion. Mr. Singh, let me actually take this to Tom Varakan of the BJP, who's also joining us on the broadcast. Mr. Varakan, the fact that there is one tweet that has come out accusing the Supreme Court, the apex court of the country, of casteism, that's come out from the member of the Congress Party. Congress Party, on the other hand, is also going ahead making it a political issue. Of course it is. However, they are sort of not denying completely on what Udit Raj has stated when it comes to the economically weaker sections, economically backward sections of the society, so to speak, SC, STs, OBCs, etc.
This is a typical double speak of the Congress Party. They want to be on both sides. Whichever win they would join. They said, well, EWS was launched by them and what have you, and that the judgment was part of the gains that they have achieved. Be what it may. Yes, it is a decision taken by the Supreme Court. We welcome it. We will comment properly on this after reading the judgment, because I think it's a little premature and will be injustice to the Honorable Court without having read the judgment properly to make comments. And I strongly condemn the statement of that gentleman from the Congress who has already tweeted without having read. I can assure you he has not read the judgment yet and has gone on public record. This is basically a person who is,
The Supreme Court has upheld the 10% EWS quota that was announced by the Modi government just a few months ago. To talk more on this, I am being joined by senior Congress leader Udit Raj. Sir, how do you see this verdict that has come in from the Supreme Court, where the Supreme Court has said that it does not infringe the Constitution when 10% extra quota is given to the economical weaker sections?
See, I don't oppose EWS reservation given to poor upper caste. But I definitely oppose the mindset of the Supreme Court. Ever since Indira Sahni's judgment, that is popularly known as the Mandal judgment, Supreme Court has been always rejecting whenever the limit of reservation exceeded in the matter of SC, ST, OBC, that there is a ceiling limit imposed by Indira Sahni case, and a reservation in any case cannot exceed more than 50%. But today the same Supreme Court says that Constitution doesn't bar it. Isn't it the mindset of the Supreme Court that the biased mindset? Whenever it comes to the SC, ST, OBC, they have a different yardstick, and when it comes to the general category, has a different stand. So I make allegation, I stand by it, that the same Supreme Court has been repeatedly saying that limit cannot be crossed. That limit is 50%. That is what I have said.
Sir, you had also put out a tweet just a few months ago where you have called the Supreme Court casteist. Why have you put out this tweet, sir?
I said. Why
do you think so that the Supreme Court is casteist
yes,
when the judge...
I have given the logic. If there is anybody to contradict my logic, I'm ready to debate. In fact, why all the judgments so far have been judgments of Supreme Court that the limit cannot exceed. Ceiling imposed was 50%, which cannot be exceeded. But today the same Supreme Court interpreting that the Supreme Court, that Constitution doesn't bar. What is this? That is mindset.
Right, sir. Also, we have seen the manner in which the politics has happened around it. People are already, you in fact have already raised question on this. But yes, the Supreme Court has also said that EWS section will belong to the general category. So do you also oppose this? That the...
No, the ideal situation would have been that in EWS, entire population would have been covered.
Right.
That would have been ideal position.
So do you think this is a biased mentality of the Supreme Court that is coming out right now?
Exactly. I said it. I stand by it.
So are you planning to take any action, or do you plan to challenge it?
In a democracy, what action? Supreme Court is Supreme Court, no action, but is my views which I express, and that is correct, and that based on the facts.
Right, sir. Thank you so much for your time. So that was Senior Congress Leader Udra speaking to CNN News 18, where he has said that the mindset of Supreme Court is exposed when the 10% extra quota is given to the EWS section, when according to the Indira Sahani government, the 50% quota was the upper limit. What remains to be seen, how much more politics can happen around this entire case. Till then, the entire...
the counsel for the petitioner. Shadhan sir, how do you see this verdict? First of all, 3:2 ratio coming in, dissenting voices, Justice Ravindra Bhatt and Chief Justice of India, Justice Uday Mishra.
Yeah, this is an interesting view in the sense that there are two very different visions of the Constitution envisaged by the two sets of judges. The majority view effectively sees reservation as something which was, and they have emphasized that towards the end of their view, that something temporary and should have been, it's a time to regularly reconsider that. Whereas the dissent quite clearly sees that this is a mechanism for substantive justice, and therefore the exclusion of the backward classes, SC, STs and OBCs from this EWS category, they have found it to be violative of basic structure.
Another question that arises is that Attorney General K.K. Venugopal, who was the then Attorney General, had argued that the SC, ST, OBCs cannot actually claim this benefit because they are already loaded with benefits. So do you think that that argument has somewhere or the other been accepted by the bench?
See, I will have to read, if specifically that argument has been accepted, I'll have to read the opinions, which are yet not, none of us have read it because it's not yet out. But let's assume that that has been accepted, but obviously the dissent has not accepted that argument, right? Because the dissent has seen that in fact, and we showed that to the court, that the poorest are ones who belong to OBCs and SC, ST. So even if you remove caste completely, you just look at economic criteria, you are trying to benefit the poor. But in that poor, if 70-80% are from backward classes, you're excluding them, then what's the purpose of this amendment? It's only part good. And that is the argument which two judges have accepted.
Second last question before I let you go is that a very important, in fact, an observation came in from Justice Bela Trivedi and also by one of the other judges who was concurring this opinion, is that the reservation system has to be re-looked into, and it should not be made that it's a vested interest. How do you see that?
See, that is from a formal equality perspective, I can see that what the point is being made. But the problem with that is on the ground. Do you have today enough people from backward classes who are there in government services? Do you have enough people from SC, STs who are there in government services? There are 80 secretaries to the government of India. Not more than 1 or 2 will be from the backward classes, SC, STs or OBCs. So you can finish off reservations, no difficulty, once you have genuine equality. But today, is there genuine equality on the ground despite reservations? The answer is no. Therefore, you have to further work much harder to get that first. If you get that stage first, then yes, remove it. But we are nowhere close to that yet. So therefore, this repetition, constant repetition that it's time bound, that doesn't help because the objective has not been met. You first meet the objective, then remove it, no difficulty. But there's a long way to go for objective being met. That's the point.
So this was Advocate Shadhan Farasat who was speaking to us. He was one of the petitioners. But a very, very important question that I would also like to throw to Mr. Swapnil Kothari is that we've heard Justice Bela Trivedi, we've heard Justice Pardiwala saying a very similar aspect is that reservation system has to be re-looked into, because we are already into 75 years of independence. Another part that Justice Pardiwala said is that the reservation system shall be re-looked into so that there is no kind of a re-invasion, or there has to be somewhere or the other a re-look into it. How do you see, Mr. Kothari, this observation coming in from the two judges?
Well, Ananya, the two judges have sounded out a cautionary note that today, as of this day, looking at the circumstances, we are passing on this amendment. We have no reservation, or we have no hesitation and no difficulty in that. But on another day, maybe 5 years, 10 years down the road, if we are there, or if our successors are there, they'll look at it differently and they'll throw this out, saying that it is violative, because all the time you cannot have reservations, because if the objectives are not being met, with these reservations and with these quota business, then obviously somewhere the reservations are not doing the job. And we have to look at the practicality of it, the fruition of it, in the sense that what the judges are trying to say is that looking at purely from the prism of constitutionality and transformative constitution, the 103rd Amendment is beautiful, it is sublime, and we need to pass it. But when you look at actual results of the reservations that have been there in the past, and whether the objectives of those reservations have been met or not, whether the really backward sections of the society, and I'm not talking EW, I'm talking of the backward sections. The EW has been passed today, but the backward sections of the society, whether they have really come up shoulder to shoulder with you and me, whether that has really taken place or not, that is something which needs to be taken a look at. And if we find that the results are not really appetizing or satisfactory, then we do not believe in this quota business. We do not believe in this reservation system. We will not pass this in the future. Somewhere there has to be a time span. We have to look at the results of it. And that's exactly what they are hinting at. They're telling the government that so far so good, we are with you. But maybe a couple of years down the road, we'll sit along with Justice Ravindra Bhatt and the CJI UU Lalit on this.
Swapnil, before I let you go, and this is adding to the point that Ananya was also making, before we wrap this, adding to the earlier argument of the Mandal Commission that you brought in, the fact that quota was not meant for an indefinite time. It is actually for the upliftment of a certain community. Once it attains that level playing field or the genuine equality is when they should be removed. However, do you think this re-looking at quota, which Ananya also was talking about, has been not done at all, and there is a sense of complacency, and because of which these arguments of quota after quota is being brought forth, and this is much as a general sense that I'm talking about, do you think that needs to be looked at more intrinsically?
Yes, definitely, Griha. That is a fantastic question. And in fact, that is what I believe, that the government somewhere must have shielded this or must have put it in such a way. So I'm not saying that the government has duped the Supreme Court. What I'm trying to say is that the government has tried to put up a picture saying that in as much as we try to bring in the weaker sections of the society, and I do not mean EWS, I mean the backward people, on par with the advanced sections. It's still a pipe dream. It's still not something which is going to be achieved within a short period of time, because we are a billion people, and it's going to take a while. So the picture that they have presented to the court, and I'm sure that must have been forming part of their arguments, is that there is an upliftment. These sections of society have come in. Look at these people who have occupied the top positions in society, and it's going to take a while. And so far, so good, the Supreme Court would have said, all right, we buy this argument. Let's go ahead with this. On its whole, the 103rd Amendment has a noble objective. So we cannot discount it, or we cannot bypass it. And look at the brilliance of the people who've drafted the 103rd Amendment. It's so short, it's so precise, it's put in so little words that there is very little room for any negative lawyer or any contrarian lawyer to poke holes into it and say that, look, this is going against the basic structure or anything of that sort. Because ultimately, when you have to argue before the Supreme Court, apart from the fruits of it, that's a separate argument, whether something has achieved fruits or not. That the Supreme Court will say, sorry, that's for the government to decide, and that's for the people of the day to administer and implement. But when we look at it, we have to look at it from the constitutional prism. But that will change soon. Absolutely. Eventually, after some time, the Supreme Court will get more and more progressive, Griha, and they're going to get into that part more so than the sublime nature of our constitution, or those broad, utopian ideals and, brilliant views and the gargantuan ideas that people have. That all looks very flowery and beautiful. But when it's on the grassroots, it doesn't cut ice.
Absolutely.
That's what the Supreme Court is saying.
Absolutely. Swapnil Kothari, thank you so much. And on that positive note, I'd like to take a break. This is a very, very important development that's come out of the apex court of the country, a 3:2 judgment where it has been underlined by the Supreme Court of the country that the EWS quota is not violative of the basic structure of the Constitution. Slipping into a very short break, coming right back with more news and updates. Stay tuned.
ും ഭരണഘടനാപരമായിട്ടും നമുക്ക് ഫലപ്രദമായി എങ്ങനെ പ്രതിരോധിക്കാമെന്ന കാര്യം പാർട്ടി കൃത്യമായിട്ട് ചർച്ച ചെയ്ത് തീരുമാനത്തിലെത്തിയിട്ടുള്ളതാണ്. ഏതറ്റം വരെയും പോകാം. അത് പിന്നെ ഏതറ്റം വരെയും പോകാമെങ്കിൽ എന്തു ആവാം. അതാണ് സർക്കാരിന് ആവശ്യമായ നിലപാട് സ്വീകരിക്കാം. ബില്ലുകൾ തടഞ്ഞു വെച്ചിരിക്കുകയാണ്. ബില്ലുകൾ തടഞ്ഞു വെച്ചതുമായിട്ട് ബന്ധപ്പെട്ട് നിയമപരമായതും ഭരണഘടനാപരവുമായിട്ടുള്ള പ്രശ്നങ്ങൾ എങ്ങനെയൊക്കെ കൈകാര്യം ചെയ്യണമെന്നുള്ള കാര്യം ആലോചിച്ചുകൊണ്ടിരിക്കുകയാണ്. ഗവൺമെൻറ് ആലോചിച്ചുകൊണ്ടിരിക്കുകയാണ്. ഗവർണറെ ചാൻസലർ സ്ഥാനത്ത് കേരള ഗവൺമെൻറ്റിൻ്റെ നിയമത്തിൻ്റെ അടിസ്ഥാനപ്പെടുത്തിയിട്ടാണത് യഥാർത്ഥത്തിൽ അധികാരം കിട്ടിയിട്ടുള്ളത്. ആ അധികാരം നൽകേണ്ടതുണ്ടോ എന്ന കാര്യം ചർച്ച ചെയ്യേണ്ടുന്ന അവസ്ഥയിലേക്കാണ് കാര്യങ്ങൾ വന്ന് നിൽക്കുന്നത്. ആവശ്യമായ നിലപാട് നമുക്ക് സ്വീകരിക്കേണ്ടി വരും.
Okay, my colleague Neetu is with us right now to bring us more context. Neetu, we played out for our audiences a few minutes ago a governor's response to the media. And just seeing his anger, that kind of anger from a government official seems unprecedented. Could you bring us more context as to what's brought him to this point? What is the context to this story? And then tell us what we have to look forward to today, please.
See, the governor was quite angry today, saying that he will not speak to two regional media channels, two Malayalam channels, Kairali News and Kairali TV and Media One. He says that they are running a propaganda against them and they are comrades Kairali media persons, and so that is why that is a response that we saw from Kochi, from Kerala Governor Arif Mohammed Khan, quite unprecedented, and he's asking the reporters of two channels to get out from that space where he was about to respond. Now, looking forward today, what we have is that this is the last day of Chancellor that the governor as Chancellor has given to the Vice Chancellors to respond. He had sent show cause notice to 11 of them, and they have time till today. So 6 of them have already responded, and we are expecting that the others is also most likely to submit their response by today. So it's after that the governor will take into consideration all this, and then he'll take a decision on this. So it was after.
Welcome back. We're getting you some breaking news inputs now. The Supreme Court has granted a big relief to Jharkhand Chief Minister Hemant Soren. Now, the apex court of the country has said that the plea that has been filed in the High Court seeking a CBI and ED probe against Hemant Soren in the coal mining case is not maintainable. So, slight relief there for Hemant Soren. My colleague Ananya has brought us those details. Yes, Ananya.
Well, definitely it's a big relief coming in for Jharkhand Chief Minister Hemant Soren, wherein a petition that was filed before the Jharkhand High Court, which had sought a CBI and a ED probe in the coal mining case against Jharkhand Chief Minister Hemant Soren, has now been turned down. The maintainability of this petition has been dismissed by the topmost court of the country. Remember that the High Court, after hearing this petition, had said that the petition is maintainable in nature. But now what has happened is that Jharkhand CM Hemant Soren had knocked the doors of the topmost court of the country, and now the Supreme Court's big relief has come in, and clearly it is in the favors of Hemant Soren, wherein it has been said that the plea that has been filed before the High Court is not maintainable. The appeals have been allowed, and there would be no CBI ED probe petition before the High Court now in connection with the coal mining case relating to Jharkhand Chief Minister Hemant Soren. Remember that a lot of political turmoil had happened in the state of Jharkhand due to this petition and the allegations against Hemant Soren. But then now this comes out as a big win, as a big defense for Hemant Soren from the Supreme Court of India. Studio.
Absolutely. Ananya, thank you so much for joining us. Let's cut into some more breaking news that we're getting on the broadcast now. We're told that anti-hijab stir after rocking Iran. This fire has spread back home in India as well. Now, women, including Muslims, burnt hijabs as a show of solidarity with the anti-hijab movement in Iran. This protest was organized by the Islamic free thinkers in Kerala's Kozhikode town hall. These are visuals that we are bringing to you as burning of hijab is happening in Kerala This protest has been organized by Islamic free thinkers. This is happening in Kozhikode in Kerala. As you can see, many women, including Muslims, who are going ahead burning their hijabs. You would see how similar movement happened after the killing of Mahsa Amini in Iran, because of which several days of protests rocked Iran, where women had come out on the streets along with men. They were burning hijab, and they were also seen on social media cutting their hair as a sign of protest. Now all of that spreading back home in the country as well, a show of solidarity. So what is happening in Iran? Women have decided to burn their hijabs in India as well. These are visuals from this protest. Remember, this is a protest that has been called by the Islamic free thinkers. This is in Kerala's Kozhikode town hall. These are the visuals from the Kozhikode town hall that we are bringing to you. Of course, after that entire movement, the anti-hijab stir in Iran, we are seeing similar sentiments played out in the country as well. Burning of hijab, that's happening in Kerala as well. My colleague Pradeep Pillai has more details. Pradeep, very strong visuals that are coming to light from Kerala. Of course, in solidarity with the anti-hijab stir in Iran. However, what has brought this about in Kerala? Why suddenly and today?
Well, this issue has been catching media attention in Kerala for quite some time now, and as you know, the protest, the stir, the agitation in Iran has also not died down and been going on for long. So this is a group which is called the Islamic Free Thinkers. This is in Kozhikode in North Kerala. They got together at the town hall at Kozhikode, and they also burnt hijabs. They say it's a show of solidarity with the anti-hijab movement and the women of Iran who are apparently being tortured for not, adhering to the strict Sharia laws. So, as you know, Kerala on one side always has been a land of, free thinking and movement, and several liberation movements have happened here. So, this is in continuation of that. We've also seen women calling out slogans in support of the stir which is happening in Iran. So, this has got widespread media attention, and they said that they'll continue showing solidarity and keep protesting.
Absolutely. And Pradeep, I believe... Right, Pradeep, I'm really sorry to interrupt you. Brinda Adige was also joining us on the broadcast. Brinda, what you see happening in Kerala, first of all, your reactions to that, the fact that this show of solidarity to the anti-hijab stir that had emanated in Iran, and rightfully so, has come to the country. However, this is not something new that is being seen in Kerala specifically, because I believe these similar protests had been called in February as well this year.
Hello?
Yes, Brinda, please go ahead.
Yes. This is an absolutely stunning form of solidarity, because we know that not very many women in India actually come out against the hijab. This one, in solidarity with the women in Iran, just goes to show that women across the world do not want to be under the suppression and oppression of patriarchal norms, whether they are culture, custom, or religion. And this choice that women have made to burn the hijab in solidarity is great and must be looked at as a step forward in this entire fight and struggle for women's bodily liberty, women's liberty and freedom to choose what they want to wear or what they don't want to wear, and women's right to express themselves in solidarity with other women, whatever might be the choice of theirs. It's a fantastic stand, and I think all of us across India and other parts of the world stand with the women in Kerala.
Right, very important point that Brinda Adige they are making. Brinda, thank you so much for joining us on the broadcast. We leave it at that. On that note, I am handing it over to my colleague Ridhima, who takes the broadcast forward from here on.
Thanks a lot for that, Greya. Good afternoon, and thanks a lot for all our viewers for staying with us here at CNN News 18. I am Ridhima Bhatnagar, getting you all the top stories over the next 60 minutes. Let's begin with our top focus coming in from the Supreme Court, where the Apex Court has upheld the 10% quota provided for the economically weaker sections under the 103rd Amendment Act, with a 3:5 majority. Justice Maheshwari, Justice Trivedi and Justice Padiwala were in favour of the quota, while the Chief Justice of India, UU Lalit, and Justice Bhatt registered dissent against the amendment. Now, Justice Ravindra Bhatt stated that the amendment undermines the social fabric and that excluding SC and STs and OBCs is unconstitutional. On the other hand, Justice Maheshwari said it can't be set to an unreasonable classification. Remember, on the 12th of January in 2019, the government had issued a notification stating that those belonging to the economically weaker sections who are not covered under the scheme of reservation for SCs, STs and OBCs shall get a 10% reservation in the direct recruitment of civil posts and services in the government of India.
जो 10% रिजर्वेशन के खिलाफ बहुत सारी याचिकाएं आई थी सुप्रीम कोर्ट में और अलग अलग देश के हाई कोर्ट में पड़ी थी, उन सबको खारिज कर दिया है। माननीय सुप्रीम कोर्ट का कहना है कि ये जो EWS कैटेगरी है, ये कहीं से भी जो कास्ट बेस्ड रिजर्वेशन है उसको कॉन्फ्लिक्ट नहीं करता, ये किसी भी कॉन्स्टिट्यूशन का वायलेशन नहीं करता, आर्टिकल 14 का वायलेशन नहीं करता। इसलिए जो गरीब, आर्थिक रूप से जो गरीब हैं, उनको ये 10% का जो रिजर्वेशन है, ये प्रावधान यथावत रहेगा, ये चलता रहेगा, इसमें कोई रोक नहीं आई है। माननीय सुप्रीम कोर्ट ने 10% रिजर्वेशन के खिलाफ जितनी याचिकाएं थी सबको खारिज कर दिया।
How do you see this verdict that has come in from the Supreme Court, where the Supreme Court has said that it does not infringe the Constitution when 10% extra quota is given to the economically weaker sections?
See, I don't oppose EWS reservation given to poor upper caste, but I definitely oppose the mindset of the Supreme Court. Ever since Indira Sahni judgment, that is popularly known as the Mandal judgment, Supreme Court has been always rejecting whenever the limit of reservation exceeded in the matter of SC, ST, OBC, that there is a ceiling. Isn't it the mindset of the Supreme Court that the biased mindset? Whenever it comes to the SC, ST, OBC, they have a different yardstick, and when it comes to the general category, has a different stand. So I make allegation, I stand by it, that the same Supreme Court has been repeatedly saying that limit cannot be crossed. That limit is 50%. That is what I have said.
Let me also now bring in my colleagues to take this conversation forward. I have my colleague Anusha Soni joining us from our newsrooms. I also have a legal correspondent, Ananya Bhatnagar, joining us on the broadcast. Good morning to both of you. Anusha, I want to come to you first. To break down the legal jargon for our viewers, essentially the argument had been that does this quota for the EWS, does it violate equality or not? In that regard, what have we heard today? More importantly, also give us a background of who were the judges on the bench and what is the kind of dissenting voices that we heard.
To set the broad legal context for our viewers, it's a big judgment coming in from the Supreme Court of India. Part 3 of the Indian Constitution saw two changes in Article 15 and 16 via 103rd Constitutional Amendment. In that amendment, the government said that we can grant reservation up to 10% for the economically weaker sections. And as has been reported by Ananya as well, it was vociferously argued in the Supreme Court of India that only historical, social, cultural backgrounds have been the basis for granting reservations in this country. You can't really grant reservations on the basis of economic status. If you want to, financially uplift certain communities, give them welfare schemes. The government argument was that we can create a class, we can give these benefits, and the legislature has rights. What the Supreme Court has asserted today, that this amendment to Article 15 and 16 is not violative of the basic structure. It does not fall bad of the Indira Sahni judgment, and more importantly, I think that's a very important one coming in, the exception to Indira Sahni, that is 50% plus 10%, that has been given a go-ahead by the 5 judges of the Supreme Court.
So Ananya, let me also bring you in. As far as the Indira Sahni judgment, or what is also known as the Mandal Commission, there was a cap or a ceiling as far as 50% is concerned, and many critics had questioned whether that cap can be breached or not. So today, essentially, what are we hearing on those lines as far as beyond this 50% quota is concerned?
Well, definitely, Ridhima, this was a very, very important question, the constitutional question that was involved into this particular case when the Constitution bench headed by Chief Justice of India, Uday Umesh Lalit, was actually hearing this matter. And in fact, the central government had put in an argument that even if that 50% criteria is breached, it is not a violation of the basic structure of the Constitution, because it's only mentioned in the Indira Sahni judgment of the Constitution of India and is not violative of any of the provisions of the Constitution. Apart from that, what the central government had constantly argued is that the inclusion of the SC/ST or the economically backward classes into this EWS reservation is not possible, because the only ground on which this is being sought is the ground of equality. But already the SC/STs and OBCs are loaded with benefits, is the exact word that the then Attorney General K.K. Venugopal, who was arguing for the central government, had argued. And today, when we see this judgment coming in from in a 3:2 ratio, wherein 2 judges have dissented while the other 3 have actually consented to the 103rd Amendment of the Constitution of India, which brought in this 10% of EWS criteria, a very important question that arises out from the observations that have been made by Justice Pardiwala and Justice Bela Trivedi particularly, is that there is a need to actually relook this whole reservation system, and that's what Justice Trivedi says, that even after 7 decades or 75 years of independence, we shall be there and we shall have a relook into the system. And definitely the 103rd Amendment of the Constitution is not at all unconstitutional. While on the other view that has been given out by Justice Ravindra Bhatt and Justice Uday Umesh Lalit, the Chief Justice of India, is that this particular amendment is not at all is completely unconstitutional, because it does not include the SC/STs, OBCs, and it is not providing a parity to both of them. And it should not be misunderstood that they were loaded with benefits or not, because the major constituents of the SC/ST population falls within the category of the below poverty line, and that's the reason why they should also be included into this particular EWS reservation. If at all it has to continue. So this was the sum and substance of this hearing, but a big judgment coming in from the Supreme Court, a big relief to the central government, because the constitutional validity of the 103rd Amendment has now been upheld, and we are hearing that we might see a review coming into this particular petition before the Supreme Court of India.
Okay, Ananya and Anusha, I'll just request both of you to stay on with us. Let's just break down the big takeaways as far as this big judgment from the Apex Court is concerned, and we'll continue the conversation with our colleagues and guests. So let's break down the details in terms of what we have heard. Why are we saying this is a landmark judgment and a big win as far as the Modi government is concerned? Now, essentially what this means today is when the Apex Court upheld the EWS quota, that the quota on basis on one's economic situation is essentially good in law, which essentially means that this is not in violation as far as the Constitution is concerned. Quota for economically weaker sections doesn't, as I pointed out, doesn't violate the Constitution. As I said, you had 3 judges in favor and 2 dissenting, which includes the CGI UU Lalit as well. The centre can create a new class as far as this reservation is concerned. What this essentially also means is that this is going to be a vindication for affirmative action based on the economic status. A lot of questions had been asked because you have a 50% ceiling. So if it breaches that, does it then mean that you will have a sense of disparity that will will be seen in days to come? On those lines, it says that 50% ceiling limit can be breached in exceptional situations. Let me also now bring in our guest to understand how they see this landmark judgment. We have with us lawyer and political analyst Deshratan Nigam. We also have Sanjay Rana, lawyer and political analyst. Good to have both of you on the broadcast with us. Deshratan Nigam, I'd like to begin the conversation with you. How do you see this verdict coming in from the Apex Court upholding the EWS quota?
This is Ridhima, this is a very good verdict, and it does not affect in any way the existing reservation system that we have with respect to scheduled caste, scheduled tribe and OBC. They enjoy the benefit. The poor and the rich in that category enjoy the benefit. So far as this affirmative action based on economic criteria is concerned, the Supreme Court by 3:2 majority has held that it is not violative of the Constitution. They have upheld its constitutional validity and the 103rd Amendment, which brought amendments in Article 15 and 16. So they are saying it does not violate the principle of equality, because the concept of equality is among equals, not between unequals. So therefore, they have upheld it.
They said it's a reasonable classification. It is well within the power of the parliament to bring such kind of an amendment, being reasonable. Secondly, they talked about the temporary nature of this, reservation under EWS. EWS is not based on lineage. It's temporary. Once you get out of it, you are out of that limit, the economic criteria, then you do not get the privilege.
True.
So at the same time, if you look at the transformative constitutionalism that they talked about, that this affirmative action is transformative in its nature, because what wrong the poor in the remaining 50% have done, that is the compassionate ground that they have also taken based on constitutional principles. They have also said that it does not violate the 50% ceiling as laid down in Indira Sahni's case, because under Indira Sahni's case, there was no economic criteria or EWS system in the constitution. So that was purely based on socially and economic education backwardness. Economic criteria was not there. So economic aspect is not even considered in Indira Sahni's case, and therefore 50% did not apply. And therefore, this 10% that has been carved out is from the remaining 50%. It is not Indira Sahni's 50%. It is the remaining 50% it has been carved out. So there is no.
That's where a lot of questions are being raised, Deshat and Nigam, and I want to bring in Sanjay Rana here, that because you already have a cap as far as this 50% quota is concerned, when you get this EWS quota as well, what happens to those who are fighting it solely based on merit? Does it become even more unfair to them? That's the criticism that's coming in. Sanjay Rana?
Hi, Anusha. Good afternoon to you and good afternoon to my fellow panelist, Mr. Nigam. Obviously, Mr. Nigam has covered most of the things, but if you look at this judgment, it's obviously a landmark judgment for all of us, because I will treat it as a part of the society. And if you look at a lot of upper caste people not getting a chance to get fair election procedures because of financial situation. And when you talk about the carving and it's going beyond the structures, administrative is totally different. It's just made a 50% as a cap because of administrative process. The government can create a structure, create a new structure for this EWS class, which can be implemented by the government. And obviously, if you look at the reservation system, Anushka, it should be reviewed every 10 years. But from last 75 years, there's no revision because none of the government have a guts to discuss on this particular reservation scenario, which we implemented in our constitution. So therefore, it's very, very important, as Justice Bela Trivedi mentioned categorically, that it should be reviewed. Whatever the procedures is going on, we need to review the continuously reviewing every 10 years, every 15 years, every 20 years, whether it's required or not required. We are not touching that portion, is absolutely intact. But this portion is going to be additional, and you know how much people are going to get a benefit out of it. Approx, if you look at the population of India, is approx 140 crores, and out of 140 crores, if you are talking about 10%, it's going to be around 25 crore people will get benefit. Those who are not getting a benefit and this was neglected from the society. So we need to look at and take the collective, all the poor, whosoever, whether it's a caste basis poor or financial poor, we need to take them along and make them as a part of our society. Till the time we are not doing this kind of activity, we are not involving, not taking along with us, there is going to be a problem for the society, because equality is very important. But it is not at all. Obviously, political party will make the issue. It will create and find out the loophole.
You know, we'll talk about the political aspect about it in just a bit. We're already seeing reactions from the likes of Udit Raj and others. But I want to continue the conversation with my colleague Anusha, who continues to be with us. Anusha, while we're saying that, you know, the majority judgment today is that they've upheld the EWS quota, it does not violate equality or what the constitution represents. But I want to talk to you about the two dissenting voices that we saw as far as this judgment is concerned as well. Usually, and you would know this better, that usually whenever you see dissenting voices, they usually become crucial in terms of what we can expect possibly in years to come. Can they pave way for a majority decision in years to come? What do you make of the dissenting voices, especially coming in from the CGI himself, who's set to retire?
Well, I couldn't agree more, Ridhima. And who can forget the historical dissenting voices in Indian judicial history that have made eventually the part of laws, and you have had multiple judgments turned upside down. Not to say that this is going to happen in this case, but yes, you're rightly pointing out that Justice Ravindra Bhatt and Chief Justice of India Lalit had some very important points points to make, and perhaps Mr. Deshratan Nigam and Mr. Rana can also talk about these points. Reservation was never supposed to be about financial upliftment. Reservation was always about getting a seat on the table. Reservation was always about representation of those communities which, because of their homogeneous caste or religious identities, were always segregated or discriminated in society. The argument which the two dissenting judges really put on the table is that if that is the sole basis of reservation, for financial upliftment, you do not require to create a separate class. And Mr. Deshratan Nigam, if you can answer this question, that are we also opening up a Pandora's box? Because you have breached the Indrasani ceiling, you have created a new class, there are various people across this country which will fit into that 10% category, and nothing stops the state governments from getting various other delegated legislations or subordinate notifications. Mr. Nigam.
Yes, Anushka and Ridhima, one thing is very clear, that Indira Sahni's judgment, the ceiling which has been laid down there, the 50%, talks of socially and educationally backward. And this is the economic criteria, economically weaker sections. So this Indira Sahni's judgment does not apply. So far as opening the Pandora's box is concerned, let me answer that the poverty itself leads to discrimination. The persons who are very poor are unable to, achieve their aspirations. And actually that leads to a lot of backwardness in them itself, because today if you talk to any poor person, he says he's unable to stand on equal, and therefore this criteria which has been upheld is constitutionally valid. It does not breach the 50% the limit which has been set up. And secondly, 50%, as pointed out in the judgments, affirmative judgment out here, is this 50% has not been mentioned in the constitution.
Yeah, I mean, Mr. Nigam, in all fairness, a lot of our constitution is written in the Supreme Court judgments via the constitution benches and not really in the text of the constitution that you and I perhaps pick up and read. Mr. Rana, I'm coming to you and I will reiterate the same question to you. Does the constitution really envisage a reservation based on the economic status? That is the point that my colleague Ridhima also pointed out, has been talked about in the two very interesting dissents coming in from Justice Ravindra Bhatt and the Chief Justice of India, who is presiding the bench.
Maybe my opinion is different. Obviously, as I mentioned, that Nigam was explaining very categorically what exactly was the case. If you're talking about the 50%, if 50% is not at all disturbing, please understand the reservation which we have obviously is on the basis of varied criteria, on the basis of the caste and education and social justice. When we talk about this one is not creating anything. It's the poor. It's uplifting the poor, those who are poor. Obviously, we have some system on the basis that we can judge who are there, who is going to be part of this particular segment, I would say, part of this club. I don't see any argument. Obviously, as I mentioned earlier, that political party, those who are against this, try to find out the gaps and it will create a story, but actually is not at all hampering the social justice, social phenomena which we have at this point of time in our system of the reservation. It's not at all hampering, and 50% is not a benchmark. It can be exceeded. And obviously, if you look at the EWS, EWS is temporary, it's not a permanent. And none of the reservations are permanent. Government can review after 5 years, after 10
years. It was said by Justice Pardiwala today that the entire idea of reservation, whether for SC, ST, OBCs, as envisioned by Dr. Ambedkar, was actually a temporary provision, but it never really went away from our constitution.
Yeah, and that's exactly what I want to discuss with Deshratan Nigam. And, this is something that you touched upon earlier as well, Deshratan Nigam, that, as far as the EWS quota is concerned, once you don't fall into that category, that quota is taken away. But as far as a larger reservation is concerned, do you think we also need a relook as far as the second generation or third generation who fall under that quota is concerned?
Yes, certainly, quota system or reservation cannot be a permanent feature. Once you have availed of it, you cannot have, further generations having it. But that lacuna we have in our system, that lineage, it has become hereditary. And one after the other, the generations do not want to leave the reservation system under SC and ST quota. Although under OBC, you have a concept of a creamy layer. However, here itself, in EWS quota, there is nothing called permanency.
True.
Once a person has received it, he goes out of the EWS quota, and therefore his further generations will not be able to, unless and until they satisfy the criteria laid down. So this does not create a permanent class of reservationist, and therefore it is constitutionally valid, and the Indira Sahni case does not apply at all. That stands on a separate footing of educationally and socially backward class. So this is EWS, a reasonable classification, and once an amendment has been made in the constitution, then it becomes a part of constitution. To say that it was not there earlier, then so many hundreds of amendments have been made, they also do not fall within the amendment within the constitution. So therefore R is an adaptive constitution, evolutionary constitution, and it evolves with time. And secondly, it also raises a very important aspect: how come the temporary nature of reservation has become permanent in our constitution?
True. I'll just request our guests to stay on with us. I'll request our colleagues also to stay on with us. Let's listen into some political reactions and we'll continue the conversation.
Shugata, you have you've learned about the Supreme Court judgment. It has upheld the government's decision, the Parliament's amendment. How do you respond to this development?
I'm happy at this development. The 103rd Constitution Amendment, reserving 10% seats in colleges and government jobs for economically weaker sections among the upper caste, was passed by all parties unanimously.
Okay.
It was challenged in Supreme Court. Now Supreme Court, in its present historic judgment by a majority of 3-2, have upheld the reservation for economically weaker sections. I think it's a step forward in bringing social and economic equality in the country. The majority of Supreme Court judges have ruled in favor of the reservation.
Right, and you're happy about it?
I'm very happy about it.
What would you have to say about this judgment where the majority of the judges have ruled in favor of, the EWS quota?
The constitutional amendment providing reservation to the economically weaker section of society was under challenge. The full bench of the Supreme Court, the learned 5 judges, examined all the aspects after hearing all sides concerned. As far as we are concerned, we believe that to extend help to economically weaker section youth, you see, is a welcome step. Because see, in our country, the large section of poor people are not able to afford or rather buy, you see, positions either in school admissions, college admissions, or postings, etc., jobs, etc. So I think granting to them the some kind of a benefit for coming on par is a major step to bring about equality in the society. It does not violate the basic structure of the Constitution of India, and therefore it is held to be valid.
I want to continue the conversation with our guests. While we've seen the majority bench in favor as far as the EWS quota is concerned, you're already seeing a lot of political voices who are now dissenting, one of them being Udit Raj. Sanjay Rana, I want to bring you in. Essentially what Udit Raj is saying, that I am not against as far as EWS reservation is concerned. What I'm opposing is the mindset of the Supreme Court. How are you seeing the political reactions?
Ridhima obviously is a political stand. I was watching his comment a few minutes back before this debate started. Sure. Obviously, what he's trying to just manipulate, because he's not understanding, he's not challenging. If he's saying he's not challenging, he's understanding the mindset. Other people are trying to look at his mindset. Obviously, everyone has a right to live in this country and uplift, and have equal right in this country. But if you're talking about, I understand he's already representing ST people, is no issues. We are none of the constitution and none of the article are harming anyone or not, or bypassing anyone's right. It's giving additional things to the people, those who are poor, and we need to accept. We need to come with open heart. And if you want to have a debate,
Sajid
we
Rana,
need
I'll
to have a
just
healthy
request
debate.
you to stay on with us. We have SP Singh Baghel, the MOS Law and Justice, also now joining us on the broadcast. सर बहुत बहुत धन्यवाद हमसे बात करने के लिए. आप कैसे देख रहे हैं आज का ये लैंडमार्क जजमेंट 3:2?
मैं आज के माननीय सर्वोच्च न्यायालय के 3-2 के इस फैसले का स्वागत करता हूं, अभिनंदन करता हूं. और ऐसा फैसला देकर के उन्होंने एक सामाजिक न्याय का काम किया है. और मैं आभार प्रकट करना चाहूंगा 2019 में माननीय प्रधानमंत्री जी ने जो सवर्ण वर्ग में आर्थिक रूप से कमजोर लोग थे उनको 10% आरक्षण दिया. सुप्रीम कोर्ट में ये मामला गया और संविधान पीठ ने इसके पक्ष में 3-2 के फैसले से इसके पक्ष में बात कही है. पहले दीनदयाल उपाध्याय का जो एक सपना था अंत्योदय का, तो अंत्योदय की परिभाषा को नरेंद्र मोदी जी ने बदला है. अंत्योदय का मतलब केवल अंतिम व्यक्ति को आवास, चिकित्सा या गैस सिलेंडर या आयुष्मान कार्ड नहीं है, बल्कि 72 साल की आरक्षण से और संविधान लागू हुआ और 75 साल देश की आजादी अमृत महोत्सव मनाने पर भी सवर्ण समाज के कई गरीब घर के लोग ऐसे हैं जो 3 पीढ़ी में चतुर्थ श्रेणी कर्मचारी भी नहीं बन पाए. ये बहुत महत्वपूर्ण इस बात है कि इनका कंपटीशन, अब जो ये 10% बच्चे होंगे इनका कंपटीशन आपस में सवर्ण समाज के एक सी अकल वाले, एक सी शक्ल वाले, एक से कपड़े वाले, एक से दुख वाले, एक से दर्द वाले और एक ही शैक्षिक, सामाजिक और आर्थिक स्थिति में समान रूप के बच्चों का आपस में कंपटीशन होगा. अब ये 10% वालों का कंपटीशन की कॉपियां आपस में जीतेंगी, ना कि इनकी देहरादून के दून स्कूल या मेयो कॉलेज या सिंधिया या शेरपुर में पढ़ने वाले बच्चों के साथ होगी. इनमें से जो बच्चा होशियार होगा वो नौकरी पाएगा. और ये इस प्रकार के एक सही मामले में नौकरी का अंत्योदय प्रधानमंत्री जी ने किया, जिस पर मोहर संविधान पीठ ने लगाई है.
जी, जो लोग इसको अपोज कर रहे हैं, काफ़ी सारे लीगल एक्सपर्ट्स भी डिवाइडेड हैं, उनका ये कहना है क्योंकि 50% आरक्षण ऑलरेडी है, आप उसके ऊपर ये 10% आरक्षण अगर लाते हैं तो एक सेंस ऑफ डिस्पैरिटी होता है या फिर ये कॉन्स्टिट्यूशन को वायलेट कर सकता है. इस क्रिटिसिज्म को आप कैसे देखते हैं?
जिस प्रकार से ये 10% आरक्षण भी संविधान में संशोधन करके लाया गया है, ऐसी कोई संवैधानिक दिक्कत होगी तो उसके लिए भी पार्लियामेंट है. और जब माननीय सुप्रीम कोर्ट ने इसके पक्ष में कहा ही है तो वो भी निर्णय से सहमत होंगे. देश काल परिस्थितियों के अनुसार संविधान में भी संशोधन होते रहे हैं और तो इसकी आवश्यकता होगी. ये लोहिया के गैर बराबरी समाज, ये बाबा साहब का समतामूलक समाज और जो पंडित दीनदयाल उपाध्याय ने अंत्योदय की तरफ की थी, इनकी भावनाओं के अनुरूप ये फैसला है. और मोदी जी का जो निर्णय था वो इन सभी महान पुरुषों की जो गरीब दरिद्र नारायण के बारे में जो कल्पना की गई थी वो हुआ.
जी, सिंह साहब मैं आपसे जी
जन्म लेना का कोई अधिकार नहीं है. जो ये लोग विरोध कर रहे हैं, कोई व्यक्ति एफिडेविट पे कह सकता है कि अगला जन्म वो पैसे वाले, क्या पता देश के बड़े पैसे वाले 5 उद्योगपति अगला जन्म गरीबी में ले लें. तो गरीबी पाप नहीं है, ये एक अभिशाप है जिसको दूर करने का काम मोदी जी ने किया, जिस पर मोहर माननीय सुप्रीम कोर्ट ने लगाई है. ऐसे लोग जो विरोध कर रहे हैं ये ऐसे वातावरण में रहे जहाँ ये कोई दूषित मानसिकता के लोग हैं जो समाज को तोड़ना चाहते हैं, भाईचारा को खत्म करना चाहते हैं और समतामूलक समाज की स्थापना नहीं चाहते हैं. मैं तो एक कदम और आगे बढ़ के करना चाहता हूँ कि समतामूलक समाज नहीं बल्कि समतामूलक संपन्नता होना चाहिए, ना कि समतामूलक विपन्नता होनी चाहिए.
जी साहब, मैं आपसे एक चीज़ और पूछना चाहती हूँ. जो कांग्रेस पार्टी है वो खुल के तो अपोज नहीं कर रहे हैं, बट कुछ ऐसे रिएक्शंस हैं जो काफ़ी सवाल खड़े कर रहे हैं. उनमें से एक है कांग्रेस के उदित राज. वो ये कह रहे हैं कि मैं EWS रिजर्वेशन के खिलाफ नहीं हूँ, पर मैं खिलाफ हूँ एक मानसिकता जो हम सुप्रीम कोर्ट के बेंच की तरफ से देख रहे हैं.
नहीं, सुप्रीम कोर्ट देखिए अपने देश में ये है कि लोअर कोर्ट ने कोई फैसला किया है, दोनों पक्षों में जिसको पसंद ना हो वो हाई कोर्ट जाए, हाई कोर्ट के फैसले के खिलाफ सुप्रीम कोर्ट जाए. पार्लियामेंट ने कुछ किया है तो लोग गए ना सुप्रीम कोर्ट, और सुप्रीम कोर्ट में भी संविधान पीठ ने 5 लोगों के जजों में, जिसमें चीफ जस्टिस ऑफ सुप्रीम कोर्ट भी थे. ये अलग बात है कि उनका फैसला कुछ दूसरा था, लेकिन 3 लोगों ने इसके पक्ष में कहा है. सुप्रीम कोर्ट पर इस प्रकार की टिप्पणी करना डेमोक्रेसी को कमजोर करना है. हमारे उदित राज जी, बाबा साहब भीमराव अम्बेडकर को हम सब लोग मानने वाले हैं। उन्होंने कार्यपालिका, विधायिका और न्यायपालिका की भूमिका को बहुत ही स्पष्ट रूप से रेखांकित किया है और हमें लक्ष्मण रेखा को पार नहीं करनी चाहिए।
बघेल साहब, अनुषा इस तरफ हो, एक सवाल मैं आपसे पूछना चाहती हूँ। उदित राज की बात हो रही है और बहुत सारे ऐसे कानून के विशेषज्ञ हैं जिनका कहना है कि संविधान में ये जो सारे प्रोविजंस थे, चाहे आर्टिकल 15 में हो या 16 में हो, जो अनुसूचित जाति और जनजाति की वजह से बने हुए थे, जनजाति के लिए बने हुए थे, उनके सामाजिक कारण थे, उनका कोई फाइनेंशियल रीज़न नहीं था। और अगर आपको किसी भी समुदाय को किसी तरीके का इकोनॉमिक वेलफेयर या फाइनेंशियल वेलफेयर देना है तो सरकार अपनी योजनाओं से दे सकती है, उसके लिए आपको आरक्षण लाने की ज़रूरत नहीं है। और कहीं ना कहीं ये SC/ST को जो रिजर्वेशन दिया गया है उस पर सवाल उठाता है। इस तरह का जो क्रिटिसिज्म है, आलोचना है, उसके बारे में आप क्या कहेंगे?
उनको ये भी देखना चाहिए कि मंडल कमीशन में जो बैकवर्ड के लिए है उसमें क्रीमी लेयर है
जी,
ठीक है ना। उसमें क्रीमी लेयर है जो आर्थिक आधार पर है, अथवा माँ बाप दोनों क्लास 2 अफसर हैं या फादर क्लास 1 अफसर है, तो वो मंडल कमीशन के आरक्षण का भी लाभ नहीं उठा पा रहे हैं। तो वहाँ भी तो आर्थिक स्थिति रखी गई है ना, वहाँ भी आर्थिक स्थिति रखी गई है। जब देश आजाद हुआ तो देखा गया था लगभग सभी SC और ST आर्थिक रूप से कमजोर ही थे, शैक्षिक रूप से भी थे और सामाजिक रूप से भी थे। और उस समय, अब आप ये देख रहे हैं कि अभी भी OBC में आप ये देखो कि 27% बैकवर्ड का जो आरक्षण है वो भी मंडल कमीशन को लागू हुए तमाम साल हो गए हैं, अभी वो फुलफिल नहीं हो पा रहा है। तो कहने का मतलब है कि दोयम दर्जे की शिक्षा लेने वाला वर्ग जी,
बहुत सारे समुदाय हैं, चाहे वो मराठा समुदाय हो या जाट समुदाय हो। कई बार वो सुप्रीम कोर्ट गए, इस पे पूरा एक बहस भी हुआ, इंदिरा सानी जजमेंट को बोलकर कहा गया कि नहीं, हम उन सीलिंग को क्रॉस नहीं कर सकते। इस तरह की जो समुदाय विशेष की आरक्षण की जो राजनीति हुई है, क्या इस जजमेंट का उस पर कोई भी प्रभाव पड़ेगा?
देखिए, हमारा देखो, अपने देश में एक बहुत अच्छी बात है कि किसी को कोई चीज में दिक्कत ही होती है तो वो PIL भी कर सकता है, और विधानसभाओं के निर्णय से दिक्कत होती है तो हाईकोर्ट जाते हैं, पार्लियामेंट से कोई दिक्कत होती है सुप्रीम कोर्ट में जाते हैं। सुप्रीम कोर्ट में भी ये नियम बनाया गया संविधान में कि भाई इस प्रकार के जो संवैधानिक मामले हैं जिसमें संविधान संशोधन किए गए हैं वो संविधान पीठ सुनेगी। संविधान पीठ भी एकल नहीं होती है, 5 लोगों का होता है, जिसमें बहुत सबको समानता का अधिकार दिया जाता है, और उसमें किसी को कोई देश संविधान से चलेगा, कानून से चलेगा, अब ये भावनाओं से नहीं चलेगा।
जी बिल्कुल। There are also some protests happening. बघेल साहब, बहुत बहुत शुक्रिया हमसे बात करने की. I really appreciate your time. Giving it back to my colleague Ridhima. And Ridhima, these protest shots coming in from different parts of the country.
Absolutely. Anusha, will request you to stay on with us. I believe we're getting some live visuals now coming in, and these are coming in from Trivandrum. You have the Youth Congress now protesting in Kerala. This, of course, post that landmark judgment that we've seen from the Apex Court, which was 3:2 upholding as far as the EWS quota is concerned. We'll try and get more details of what really is happening, which are these locations where we're seeing Youth Congress workers protests. But as of now, the visuals that you see on your screens are coming in from Trivandrum, where you have Youth Congress workers. There are also water cannons that are now being used. You can see a huge deployment.
The mayor has said that she has not written such a letter, and this incident happened on the day when she was out of office. She was not even in the state. She was in Delhi. That's the date that has been given. But there has been several protests by the opposition, both the Congress as well as the BJP, in this matter, demanding her resignation.
Okay, we'll try and get more details, but we continue to stay with those visuals coming in from Trivandrum, where, as I pointed out, you have Youth Congress workers. They're protesting, some water cannons being used. There is some altercation happening with police officials on the ground. The police also trying to contain the situation. All of this in the backdrop of that landmark judgment that we've seen that came from the Apex Court a short while ago. What really is happening? My colleague Neetu now joining us on the broadcast. Neetu, why are the Youth Congress workers protesting?
Now, the Youth Congress workers are protesting, demanding the resignation of Mayor, Thiruvananthapuram Corporation Mayor Arya Rajendran. Now, two rounds of water cannons have been used, and there has been tear gas also that has been used by the police at this moment. But the workers are not backing off. They are protesting further. Now, this was mainly because after they are demanding the resignation of Thiruvananthapuram Corporation Mayor because a letter came out allegedly written by her to the district CPIM district secretary, and there the mayor had said in that letter she has allegedly written saying that for the 295 temporary employees in the corporation, please give a priority list. Now the mayor has categorically denied this, saying that she has not written something like this, she has not written a letter like this, and the alleged date on the letter is on the day when she was not even in office, she was not even in Thiruvananthapuram for that matter. So the protests are continuing outside the corporation office. It's a tiff between the police and the Youth Congress workers that are going on. There's heavy police presence, 2 rounds of water cannons and at least 3 rounds of tear gas have been used on the protesters, but the protesters still not backing off.
Okay, are we seeing these protests only in Trivandrum, Neetu, or are you seeing it move to other areas as well?
This protest against the Thiruvananthapuram mayor is in Thiruvananthapuram outside the corporation office.
Okay, and I could see some sort of altercation with police officials on the ground as well. What is the kind of deployment that you see?
There's heavy police presence that are here. There is water cannons that have been there is a heavy police presence deployed on the ground, but tear gas shells are also being used to disperse the workers at this scene. But so far they are not going back. They are regrouping and coming back. They're trying to push the barricades and trying to break this barricade which the police has put up.
Okay, any other activity that you're seeing around you? Give us a backdrop of what the Congress now plans to do and how they plan to escalate the protests.
Now see, the Congress has been protesting right from the day the letters have come out. Now today the Youth Congress has taken out this protest march. The opposition leader himself has said that they will be demanding the resignation of Mayor Arya Rajendran. They demand her resignation. She has given a complaint to the Chief Minister saying that there should be inquiry into this. Now these are the visuals that we are seeing outside the main road in front of corporation. Workers on one side. On the other side of the barricade, there is heavy police presence, tear gas shells that are being used, water cannons that are being used. But even after 2 rounds of water cannons and 3 rounds of tear gas shells, the workers are not going back. The Youth Congress workers are not going back. We can see that they are regrouping again, going towards the barricade, trying to break the barricade. They are sitting down in front of the barricade and protesting. So the protests are going to escalate and are going to continue in the coming days also.
So Neetu, we can already see water cannons being used on these protesters and Youth Congress workers. I saw some sort of altercation with police officials on the ground as well. Are some protesters being detained as well, or some arrangements being made on those lines as well?
As of now, the protesters have not been detained yet. They have the police are not even trying to detain them. They were trying to break them. They were trying to move them further from breaking these barricades and entering. Right now, the workers are on one side of the barricade and the police on the other end, on the other side of the barricade. Right now, the workers are sitting down and making their protest. They are not really pushing the barricades at the moment, but they are not backing off. They are sitting in front of this front of this corporation road. They are sitting down and they are protesting, and their demand is that the mayor should resign. The mayor who wrote a letter allegedly saying that giving priority, asking the CPM state secretary to give priority list of the of those that needs to be employed in the temporary vacancies. So this is something which the Congress has been raising earlier, also saying that the CPM is actually employing only their party workers or those close to them in the government jobs, be it in government sector, in LSGDs or in the PSU. So this was one of the major allegations that the Congress has raised time and again. So they are upping their protest here, the Youth Congress namely, because they say that the youth has been cheated because the mayor is trying to play partisan politics, but at the same time the mayor denying this, saying that she has never written a letter like this and she has given a complaint to the Chief Minister and asking for an inquiry into this.
So Neetu, as you're saying, let's take this point by point. You're saying the mayor as of now refuting all these allegations. How is the state government reacting? Any response coming in from the Chief Minister's office so far?
See, so far there has been no response from the Chief Minister's office, but MB Rajesh, who is the LSGD minister, though he did not respond on this, saying that the person who wrote the letter, as well as the person who allegedly received this letter, says that they have not received something like this, or they are not written something like this. But the LSGD minister at the same time has said that all these 295 employment will be done through the employment exchange themselves. So that is something which has come, but so far the government has not reacted. The party secretary has said that they will look into this. The person has said that they have not written the letter. They will look into this.
So Neetu, I can hear some sort of sloganeering that is taking place by these protesters, a sit-in dharna also. Could you help us understand what is happening around you?
See, they are sitting in protest in front of the corporation office. These are the Congress, the Youth Congress workers here. Their demand is that the mayor should resign. Mayor Arya Rajendran of Thiruvananthapuram Corporation should resign. So that is a slogan that they are raising here at this moment, saying that through this move, they are taking away employment from the youngsters in the state. The youngsters are not getting an equal chance. It's only basically the CPM cadres or the CPM workers that are getting a chance in employment, especially when it comes to the temporary workers. So they have been alleging that this is something which has been going on in the state for quite some time. The CPM and the LDF is trying to put only their people in all positions, whether it is in the LSGDs, whether it is in the PSUs or in government service when it comes to temporary workers.
So Neetu, because of these clashes that are happening with the protesters and police officials on the ground, tear gas being used, water cannon also being used, I'm assuming there must be some sort of traffic diversion or road closure that we would be seeing as well. What are the kind of precautions that are being taken that this does not become into a much bigger law and order situation?
See, protest in Thiruvananthapuram is quite common, if we can say like this, because the roads get closed. Either it's outside the state secretariat or outside the Raj Bhavan. Right now, this is one of the main roads in Thiruvananthapuram, the road in front of the secretariat. On the other side, we can see that from the other end, there is no vehicular movement because vehicles are not allowed to come in from the PMG junction to this side or from MG road towards this side. So this entire road has been barricaded and blocked from the other end itself when the Youth Congress workers started their protest. So this is something which the police have done. The traffic has been diverted from this area, definitely creating a lot of issues for the people who wants to travel through this area. But the area has been cordoned off by the police at this moment for traffic.
Neetu, I also want to understand, because you still have these protesters sitting and staging a sit-in dharna, despite their altercation with the police officials. Have you been able to speak to any workers or these protesters? What is their plan of action? Do they plan to continue it for days to come? What is the kind of assurance that they want, because the resignation is not coming?
See, the only demand that they are keeping forward is that the mayor should resign. They will not be taking anything sort of any assurances short of this. So right now their protest is still ongoing. Right now, the leaders of the protest are speaking to the workers at the moment. They will continue this protest for quite some time today, but even after these workers, even when they disperse from here, this will not end, because in the coming days, this is definitely something that the opposition, the Congress, will be taking it up. Not just the Congress, but even the BJP. The BJP is the main opposition in the Thiruvananthapuram corporation, so they are also taking up this matter. They are actually they will be meeting the governor as part of this. The councillors will be meeting the governor also in this matter. So the opposition definitely upping the ante. The protest will continue in the coming days, because this is one allegation that they have been raising time and again, that the CPM is doing nepotism when it comes to appointments, especially when it comes to temporary workers, and now they have got something in that regard. So definitely the protest will continue.
Okay, Neetu, thanks a lot for getting us all those details. This is a developing story. We'll keep tracking all these developments, but for now, we're slipping into a very short break.
നിയമപരമായിട്ടും ഭരണഘടനാപരമായിട്ടും നമുക്ക് ഫലപ്രദമായി എങ്ങനെ പ്രതിരോധിക്കാമെന്ന കാര്യം പാർട്ടി കൃത്യമായിട്ട് ചർച്ച ചെയ്ത് തീരുമാനത്തിലെത്തിയിട്ടുള്ളതാണ്. ഏതറ്റം വരെയും പോകാം. അത് പിന്നെ ഏതറ്റം വരെയും പോകാമെങ്കിൽ എന്തു ആവാം. അതാണ് സർക്കാരിന് ആവശ്യമായ നിലപാട് സ്വീകരിക്കാം. ബില്ലുകൾ തടഞ്ഞു വെച്ചിരിക്കുകയാണ്. ബില്ലുകൾ തടഞ്ഞു വെച്ചതുമായിട്ട് ബന്ധപ്പെട്ട് നിയമപരമായതും ഭരണഘടനാപരവുമായിട്ടുള്ള പ്രശ്നങ്ങൾ എങ്ങനെയൊക്കെ കൈകാര്യം ചെയ്യണമെന്നുള്ള കാര്യം ആലോചിച്ചുകൊണ്ടിരിക്കുകയാണ്. ഗവൺമെൻറ് ആലോചിച്ചുകൊണ്ടിരിക്കുകയാണ്. ഗവർണറെ ചാൻസലർ സ്ഥാനത്ത് കേരള ഗവൺമെൻറ്റിൻ്റെ നിയമത്തിൻ്റെ അടിസ്ഥാനപ്പെടുത്തിയിട്ടാണിത് യഥാർത്ഥത്തിലെ അധികാരം കിട്ടിയിട്ടുള്ളത്. ആ അധികാരം നൽകേണ്ടതുണ്ടോ എന്ന കാര്യം ചർച്ച ചെയ്യേണ്ടുന്ന അവസ്ഥയിലേക്കാണ് കാര്യങ്ങൾ വന്ന് നിൽക്കുന്നത്. ആവശ്യമായ നിലപാട് നമുക്ക് സ്വീകരിക്കേണ്ടി വരും.
Okay, my colleague Neetu is with us right now to bring us more context. Neetu, we played out for our audiences a few minutes ago a governor's response to the media. And just seeing his anger, that kind of anger from a government official seems unprecedented. Could you bring us more context as to what's brought him to this point? What is the context to this story? And then tell us what we have to look forward to today, please.
See, the governor was quite angry today, saying that he will not speak to two regional media channels, two Malayalam channels, Kairali News and Kairali TV and Media One. He says that they are running a propaganda against them and they are comrades Kairali media persons, and so that is a response that we saw from Kochi, from Kerala Governor Arif Mohammed Khan, quite unprecedented, and he's asking the reporters of two channels to get out from that space where he was about to respond. Now, looking forward today, what we have is that this is the last day of Chancellor, that the Governor as Chancellor has given to the Vice Chancellors to respond. He had sent show cause notice to 11 of them, and they have time till today. So 6 of them have already responded, and we are expecting that the others is also most likely to submit their response by today. So it's after that the governor will take into consideration all this, and then he'll take a decision on this. So it was after the Supreme Court verdict on one of the vice chancellors, that is a vice chancellor of APJ Abdul Kalam Technological University. It was after that Supreme Court order which found that appointment not valid because it did not fulfill the UGC guidelines. So based on that, the governor is saying that all these 11 vice chancellors appointments do not fulfill. So based on
Welcome back. Thanks a lot for staying with us. We're getting some breaking developments now coming in. The word coming in from the Pakistan Supreme Court is that they've ordered a registration of an FIR of the attack on the former Prime Minister of Pakistan, Imran Khan, in 24 hours. This in the backdrop of that assassination attempt that was made on Imran Khan as far as his long march is concerned in Wazirabad. Remember, he had suffered multiple bullet injuries, currently being treated at a hospital in Lahore. I believe my colleague Abhishek Jha now joining us on the broadcast. Abhishek, what are we hearing from the Supreme Court of Pakistan?
So now this confusion over filing of a FIR over this incident where Imran Khan was attacked and wounded by some unidentified people, however they were later nabbed. Finally, the Supreme Court of Pakistan has ordered that an FIR should be registered immediately and the case and investigation should be followed afterwards.
Okay, Abhishek, thanks a lot for getting us all those details. Shifting our focus then, after 2 bombshell letters, conman Sukesh Chandrashekhar has now released a 3rd sensational letter against the Delhi government and AAP Satendra Jain. Now, in this letter sent through his lawyer, Sukesh has demanded a CBI inquiry into the case. The former DG of Tihar Jail, Sandeep Goyal, can also come on the radar of the investigating agencies. Names of Delhi Minister Kailash Gehlot and several IPS officers have also now been released and revealed by this conman Sukesh Chandrashekhar in this 3rd letter. In fact, former Karnataka Commissioner Bhaskar Rao's name has also come up in this letter. Trouble for the Aam Aadmi Party does not end here. In the Liquorgate scandal, CBI has filed a plea before the Delhi court to convert Sisodia's aide and accuse businessman Dinesh Arora a witness as far as this case is concerned.
3rd letter has come in. It has been delivered by you itself to the Delhi LG. What are the contentions? And in fact, there have been a lot of details about where the transaction had happened. If you could give us the details.
Sir, this is not a 3rd letter. This is the 2nd complaint filed to the LG. This letter has nothing new. It's a subsequent to the previous letter, but some details are given. Details are given because Sri Kejriwal ji, during the press conference, he stated that he does not know the Sukesh, and Sukesh is the Mahathag, right? So that is why the Sukesh has detailed some things that where the payment was made, upon whose instruction the payment was made, at the farmhouse 50 crore rupees was delivered.
Mr. Kejriwal is also saying that the BJP is actually using him.
I'll not comment anything about the BJP's allegation or any party's allegation about the BJP, because it's a purely political things, because this agenda basically suits to BJP, right? That is why he has been termed as a BJP's agent or whatever, right? So I'll not comment on that. In fact, the credibility of my client becomes much higher because he is in the jail. He cannot be influenced. He cannot be tutored. He cannot be contacted.
सुकेश ने साफ बताया कि हर डिलीवरी के बाद AKVC के CEO जो अरविंद केजरीवाल की वसूली कंपनी है उसके CEO उनको जानकारी देकर ये बताया कि आपको 50 करोड़ की एक किस्त आपको पहुंचा दी गई है। इस पूरे मामले पर सीबीआई की जांच होनी चाहिए। दूसरा, ऐसे मंत्री को तुरंत जेल शिफ्ट करके उत्तर प्रदेश या हरियाणा की किसी जेल में पहुंचाना चाहिए, क्योंकि ये सबूतों के साथ भी छेड़छाड़ कर सकते हैं, ये गवाहों को भी प्रभावित कर सकते हैं। ये बहुत ही गंभीर मामला है। भ्रष्टाचार की सारी सीमाएं इस सरकार ने तोड़ दी हैं।
This is yet another candid confession by the thug Sukesh that the Aam Aadmi Party is a party of Mahathugs. It is a party of Ugai, it is a party of Kamai, and a party of Lutai. And today this candid confession contains many explosive, explicit, and extremely important details of where the 10 crore rupees of protection money was given to Satendra Jain, who continues to be a minister. These details cannot be hid from. It shows that whether inside Tihar or outside Tihar, आम आदमी पार्टी कर रही थी केवल और केवल भ्रष्टाचार। आम आदमी पार्टी का शिष्टाचार है भ्रष्टाचार।
Let me also now bring in my colleague Ananya Bhatnagar, who's been getting us all these details. So Ananya, we've already seen the kind of complaints that we've seen from Sukesh Chandrashekhar, essentially raising a lot of questions on the role of Satendra Jain and the pressure that Sukesh says Satendra Jain is building on him. This time around, as part of the continuation of the complaint, which are the new names that are emerging?
Well, definitely, Ridhima, remember that first of all, when we talk of these complaints, when we talk of letters written by Sukesh Chandrashekhar, we always say this, that this man has no credibility attached to him.
That's true.
He is a con man. He's conned people being the law secretary of the country. He's conned people being the home secretary of the country. But at the same point of time, investigation is needed to actually judge these claims. How true are these claims? Because remember, that this third letter, which is this third letter and the second letter that's been addressed to Mr. VK Saxena, the Lieutenant Governor of Delhi, is giving out a lot of details as to on which farmhouses did Sukesh deliver the particular amount of money, which vehicle had come in for this particular amount to be given out, and to whom these farmhouses belong to these vehicles belong to. A name of former Karnataka VC has also come in. So a lot of names being taken. A name of Kailash Gehlot has surfaced into this particular letter, clearly saying that it's not only Mr. Satyen Jain and Mr. Kejriwal, but also Mr. Kailash Gehlot, who's involved into, in fact, providing him, intimidating him inside the jail premises. So a lot of charges coming in from Sukesh Chandrashekhar, but the after effects of the second letter, we see that Mr. Sandeep Goel, who was the then Tihar DG, was transferred and has been immediately called back to the police headquarters for a new posting or not. We'll get to know in times to come. But then action is definitely being taken. 82 jail officials, the Delhi LG has recently given a nod that 82 jail officials have to be prosecuted in this particular case for actually helping Sukesh create a clout inside the jail premises. So a lot of action coming in from the government, and it is definitely, if at all, it is not a credible letter, if at all, it is not credible in fact. But at the same point of time, it definitely gives a new path to the investigation agencies to walk on. It
Absolutely, gives a lot of political fodder to the opposition parties as well. Ananya, we leave the conversation there. Thanks a lot for getting us all those details. We're now shifting our focus. The battle for Gujarat is heating up and the state is geared up for an electoral battle. This time, it's a triangular contest between the incumbent BJP, the Congress and the Aam Aadmi Party. The BJP is leaving no stone unturned as Prime Minister Narendra Modi addressed his first rally in Valsad on Sunday since the announcement of the poll dates. The Aam Aadmi Party too is striving hard to make inroads in the state of Gujarat. Remember, Gujarat will go to polls in 2 phases on the 1st of December and on the 5th of December, and results will be announced on the 8th of December. Now, Modhera, a village also famously known as the Surya Nagari of Gujarat, is the first solar village of India where people produce as well as sell electricity. My colleague Siddharth Mishra with this ground report.
In Gujarat,